Now, Live 5 has a team of reporters inside of the courtroom today where all of this is happening, and we are bringing you up to speed now on what has been going on. Michael Higdon and Blair Sable are in Columbia for us there. We are wanting to know if there is a ruling this evening. We're going to start with Michael.
And Rob, Blair Sable is in the courtroom right now, where we are expecting any moment now for a retired South Carolina Supreme Court Chief Justice Jean Toll to rule whether a convicted murderer, Alec Murdaugh, will be getting a retrial. Now, she has said from the very beginning that she does not want this hearing to drag on. We were initially expecting this to last about 3 days, but we heard from the first juror starting on Friday, the other 11 before lunch today. And then we heard from Becky Hill herself, the woman who is accused of tampering with this jury. Now, the day kicked off with Toll questioning each juror from the trial about accusations that Hill influenced the jury's verdict. Juror Z was the first of those 11 jurors called today when former South Carolina Chief Justice Jean Toll asked Juror Z about comments that she overheard from Hill. She said it affected her verdict. Now, when pressed by Toll after being presented with her original affidavit, where she actually said the jury had pressured her, she said it was a more accurate representation of what had actually happened. Now, it was after Juror Z left the stand that Toll actually informed the court that other jurors waiting to be questioned had their cell phones and may have been watching the questioning of the 3 jurors that did watch that testimony. All 3 said that it had no sway on their testimony today. Now, I just got a message from our Blair Sable, who is in the courtroom right now. She said that, again, Chief Justice Jean Toll is back on the stand. Let's go ahead and head back to that live shot right now.
2022 GS 1500-592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after-discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the Clerk of Court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the Clerk of Court. I also received testimony from the Clerk of Court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the Clerk of Court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by Clerk of Court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court.
So we've got the attorneys right now, the defense attorneys for Alec Murdaugh, and they are talking. Let's go ahead and let's listen into that.
Influence these jurors that she made these statements. With the facts resolved, the only issue is what is the law, and as Judge Toll said, that is unsettled. This is not, it's going to go through the appellate courts, and we feel strongly that we'll win.
Thank y'all.
Wait, one more question?
How important is it to you all to get a different standard for the burden of proof when you appeal this? Do you think you can win under the burden of proof that she set, or do you think you need the burden of proof that you all offer?
Well, we feel confident that the burden of proof is, that we get a presumption based on our factual findings here. And so if we win that legal standard, on this record, we get a new trial. If we lose that legal standard in our state courts, then we probably don't get a new trial. But we go to federal court where there is no dispute in the Fourth Circuit where we would end up with what the standard is, and it is a standard of presumption. So it's either going to be decided, in my view, in our favor in our appellate courts or 4 or 5 years down the road in the federal courts, unless there's a change of federal law.
And would there be a different outcome if you get another trial?
Yes, there would be. But I'm not going to tell you why.
Absolutely, yes.
But does it discourage you that Justice Toll at the end said she agreed with Judge Newman about the facts and the verdict and how it was, that it was a compelling case and all of that?
No. No. She's not going to say, oh, I disagree with Judge Newman, the facts were very thin. No, she's not.
Yeah, there's an innocent man here who's wrongly convicted.
And
we didn't expect her to say that. So.
But the appeals court say it's harmless error, is my point.
No,
they can't.
No.
They can't. This issue is not harmless error. Cannot be.
I've asked about this before. You all have said that you're investigating who might have actually committed these murders.
Yes.
Have you all found anything that you think you want to share with us?
We have developed some information. We want to get this behind us, and we'll be pursuing that in the near future.
About who committed the murder?
Who really did it?
Do you believe Alec Murdaugh has information? Because his voice is on the council. Do you think he has information about who did it?
Well, if he did, we couldn't tell you. That's called attorney-client privilege.
Do you think?
I can't think about what my client could have told me that would be attorney-client privilege. These rules are so pesky.
You have to give me credit for trying, though.
You get credit.
How did Alec react to
Thank
that?
you.
Pardon me?
How did Alec react to that?
Fine.
All right, so you've been listening in to defense attorneys Jim Griffin and Dick Harpootli in there for Alec Murdaugh, saying, of course, they're disappointed in the judge's ruling in this situation. So what's next? Is this the end of the road, or do they still have another shot at getting a new trial for Alec Murdaugh?
It's the end of the road from an evidentiary standpoint. We won't have any more hearings in Colleton County or Columbia in front of a circuit court judge. Everything will now be handled by our appeals process, the Court of Appeals. I expect them to not only file this appeal relatively soon with our Court of Appeals, but also, as you may have heard them reference there, maybe look into some constitutional violations in the federal court. There's an appellate system that protects defendants under Sixth Amendment right, so to speak. This may be the last we've heard of it at the state level from a